Chief Justice, and may it please the court.
So this is the other side.
His constitutional duty to execute the law does not give him the power to violate that law with impunity. But petitioners claim that the president was free to fire Commissioner Slaughter without cause in violation of the FTC Act as authoritatively construed by this court. And they urge, even if that firing was illegal, there is nothing that any court anywhere at any time could do to remedy that violation. The district court correctly rejected both arguments, and its judgment should be affirmed. On the merits, multi-member commissions with members enjoying some kind of removal protection have been part of our story since 1790. So if petitioners are right, all three branches of government have been wrong from the start. Congress and prior presidents have been wrong to jointly create early founding era commissions and more than 24 traditional independent agencies since 1887. And this court was wrong to repeatedly bless those laws and to unanimously uphold the exact same removal provision at issue here in Humphrey's Executor almost a century ago. Reasonable people can and do disagree about first principles, but any abstract theory that would wipe away so much history and precedent should be a non-starter. At a minimum, petitioners would need an airtight theory to justify the radical change that they now seek, and they don't have one. No tool of interpretation clearly supports the president's assertion of an unrestricted and indefeasible authority to fire the heads of traditional independent agencies like the Federal Elections Commission and the Nuclear Regulatory Commission. Plus, petitioners' theory cannot be reconciled with their own apparent position on the Federal Reserve and Article I courts. Finally, stare decisis militates against overruling a century of precedent at this late date. The political branches are more than up to the task of finding reasonable legislative solutions that strike an appropriate balance. That kind of legislative solution is far preferable than abandoning a foundational precedent on which so much of modern governance is based. I welcome the court's questions.
Was Humphrey's Executor an executive branch case?
It was an executive branch case, Justice Thomas, insofar as the FTC is an entity that is not operating under the auspices of Articles 1 and 3, but it is also a case in which Congress and the president coming together have determined that it's not part of a traditional executive department. And
did the court in Humphrey's Executor distinguish it from its earlier precedent in Myers?
The court, yes, absolutely distinguished the FTC from its earlier precedent in Myers.
Wasn't that distinction based on its function more as a quasi-legislative, quasi-judicial agency as opposed to an executive branch agency?
It was based in part on functions, Justice Thomas, but it was also based on the placement of the agency and the considered determination of Congress and the president together that this was the kind of agency that should be insulated from presidential at-will removal.
Now, you rely on the reliance into interests and started in the reliance interests of Congress and reliance interests, I guess, of others of the agency heads on the structure of this agency for so many years. What is it, 70 years, you say?
The FTC is 111 years old.
But from Humphrey's Executor?
90 years.
How would you have applied that in the overruling of Swift v. Tyson, your reliance interests?
Yeah, so Swift v. Tyson deals with a completely different kind of situation with respect to the Erie Doctrine.
So there was no reliance interest?
So reliance interest with respect to choice of law determinations. Yeah. I haven't thought through that systematically, Justice Thomas, to tell you the truth. I do think that there is a reliance interest here that is both immense and undeniable, and that is the fact that Congress and the president have determined that there are certain statutory authorities, not constitutional authorities, that's statutory authorities that the executive branch would never have in the absence of congressional legislation, that Congress and prior presidents thought should not be under the sole control of just one person. And that reliance interest would be completely destroyed by retroactively destroying the independence of traditional agencies.
I don't know what a traditional executive administrative agency is, but could Congress limit the removal authority of the president in a newly created executive branch agency. Let's say, for example, a few years ago, EPA became an executive branch agency. It was more of an administrative agency, a sub-cabinet. Could it, in doing that, limit the removal authority of the president, of the head of the EPA, or Homeland Security?
I think it is within the realm of possibility, Justice Thomas, and I don't think that the court ex ante should adopt any kind of categorical rule precluding that.
No, I'm trying to, again, the SG was asked about the logic of his.
The limiting boundary.
What's the logic of yours? How far does it carry you? If this is an executive branch agency, and your distinction is this is a multi-member agency, why doesn't the logic take you to a single head agency also?
So you're asking whether a single-headed agency could be converted into?
No, I haven't gotten there yet, but that would be the next step in order to make them removable, to make them the heads of the agency or the principals removable.
So there are constraints. One of the constraints is that the creation of the agency and the insulation from presidential control cannot interfere with the president's conclusive and preclusive constitutional authorities.
But you still haven't told me, why can't tomorrow morning Congress decide that the Secretary of Congress should be removable and it should limit the president's authority to remove the Secretary of Commerce?
That would be squarely foreclosed by this court's decision in seal of law as we understand it. And that is to say, this court in seal of law held that there is a particular serious threat to individual liberty that is posed by single-headed agencies that wield significant executive power.
Could Congress convert all these departments into multi-member commissions? The Commerce, EPA, Department of Homeland Security, Department of State, convert them all into multi-member commissions and make them removable only for cause?
No, I think, Justice Kavanaugh, that we're looking at three buckets here. In one bucket, including the Department of State, you would have departments that under no conceivable circumstance could practicably be converted to a multi-member commission because they are wielding so many of the president's conclusive and preclusive constitutional authorities. But that is a relatively small bucket. Let's say Department of State,
Justice and Defense.
Justice, Defense, Homeland Security, probably.
Are you saying, though, that they're limited by practical concerns or constitutional concerns?
Right.
Constitutional concerns and then practical concerns.
What are they?
Come up as well.
Well, let's put aside the practical concerns. I'd like to understand just the answer to Justice Kavanaugh.
Gorsuch.
Why tomorrow Congress couldn't transform every
Great question.
official into a multi-member group? What's the constitutional problem with that, I think is what my colleague was getting at.
Absolutely. And the constitutional problem, in our view, is that Congress cannot limit the president's authority over officers who are wielding the president's conclusive and preclusive constitutional powers. And that is a line that goes all the way back to Marbury v. Madison. It's a through line through this court's jurisprudence.
Why wouldn't that apply?
The FTC has the authority to enter foreign agreements, right? I mean, how do you decide what's conclusive and preclusive?
Right.
It does not have the authority to enter into foreign agreements on its own, Justice Barrett. The statute expressly provides that the Secretary of State's approval is required before any kind of agreement is executed, and the Secretary of State, of course, is subject to the president's plenary removal power.
You talked about three, I'm sorry.
I just want to make sure I understand, because it's fairly basic. I mean, are there some cabinet departments that you say Congress could just take over? Department of Veterans Affairs, Department of Education, they think, well, we experts can do a better job of it. And so we're going to say there is now an agency, the Agency for Education, and it will be run by, whether it's a multi-member group or not. We think it's important for Congress to have greater control over education. So we're creating this new agency, and its authorities will be everything that the current Department of Education has, except it will be run by a commission, and they can only be removed for cause. Is that all right?
Yeah, I think that it is probably within the realm of possibility for agencies, yes, Chief Justice Roberts. And the constraint historically has been that these types of determinations have been made through a process of political accommodation between Congress and the president, and over the course of more than 200 years, we have not seen.
Well, I mean, I'm sorry to interrupt, but sometimes that accommodation is greater than in other times. I mean, we have situations, let's say, where the Congress, both houses are controlled by one party and the president is of the same party, and they may decide that the government would be structured better than by taking over these entities. And so which departments could Congress impose a multi-member commission instead of a secretary?
Yeah, so if you're asking about which ones could be converted today, I think it's probably a pretty small universe in terms of the numbers that could be wholesale transformed as they are currently constituted. Why? Because it appears that the vast majority of executive departments wield at least some powers that this court would deem to be conclusive and preclusive, including under the standard that this court enunciated.
Well, how are those, I'm sorry, keep going.
Including under the analysis that this court set out just last term in Trump v. United States, where at pages 620 to 621, the court explained that the president does have a conclusive and preclusive authority with respect to certain criminal investigations and prosecutions, and that informed the court's determination about whether the acting attorney general was subject to at-will presidential removal. It turns out that the vast majority of these executive departments do have some kind of criminal investigative authority, including armed law enforcement agents authorized to make arrests. Now, that's a significant bucket. You probably have
Every agency in the government today has armed police officers.
everyone.
Armed police force.
Yeah.
Is that really the test of what's conclusive and preclusive?
So we're not
I mean,
saying.
it rhymes, but I don't know what it means.
Justice Gorsuch, I think you're making a good point insofar as you're saying insofar as Your Honor's point is that there's a lot of what these agencies do that would not be deemed conclusive and preclusive, and we absolutely acknowledge that. And
So the answer to the Chief Justice's question is tomorrow we could have the Labor Commission, the Education Commission, the Environmental Commission, rather than Departments of Interior and so forth.
So I don't know that you could do it tomorrow because, like I said, for the vast majority of agencies, there are at least some conclusive.
So it has, what's the percentage then?
So I don't want to pretend, Justice Gorsuch,
I want to know where the threshold of preclusive and conclusive comes in.
Yes, and so what we would say is that if the
Is it a mere scintilla?
I think that's why I think you would have a separation of powers problem if an agency, even if it's a vast agency wielding a broad panoply of powers, if one of those powers is the president's conclusive and preclusive authority.
But what is that?
The officers who are exercising that power are insulated.
So long as one person in the agency is exercising conclusive and whatever that means, that's enough.
So it's enough to have a separation of, and I wouldn't just say person, I would say a principal officer. It's enough to generate a separation of powers problem. And what is the remedy for that problem, I think, is an analytically more difficult question.
What's the difference?
It strikes me, Mr. Agawa, as I listen to this, if you go back to, let's say, the Education Department with which the Chief Justice raised, that the more realistic danger here is that we'll have an Education Department as authorized by Congress, by law, that won't have any employees in it.
I think you're absolutely right, Justice Kagan, that there are competing dangers here, and it makes a whole lot of sense to us.
Completely irrelevant.
Real-world dangers that we know are a virtual certainty that would result from adopting petitioner's constitutional theory, and to contrast those with purely hypothetical risks that have never materialized over the course of American history, and even in the unlikely event that Congress tomorrow was to try to start taking cabinet departments that have been around for a long time and to convert them wholesale into multi-member agencies, which they have never tried to do before. But even if they tried to do that, of course, that would be subject to a presidential.
Well, I think if there's one thing history shows is that we can't anticipate what might happen. And so we might be able to predict what is likely to happen in the very short term, but we don't know. I mean, if we decide this case in your favor now, we don't know what a Congress in 15 or 20 or 30 years might do. We might be able to predict what's likely in the short term. So, I mean, this is going to have longer term implications.
So absolutely, but let me make 2 points on that. First, there is currently no constraint there's currently no case that has ever held that Congress cannot give for-cause removal protections to principal officers serving to a single layer of for-cause removal protection for principal officers serving on a multi-member commission. And nevertheless, notwithstanding the absence of any such precedent throughout American history, we have not seen an epidemic of these problems. In fact, we haven't seen this problem materializing at all. But let me make one other point about the real-world danger that is imminent right now that we know will happen. And that is that if petitioners get their way, everything is on the chopping block. And we're not just talking about the FTC. Opposing counsel said we're not challenging right now the Federal Reserve. We're not challenging Article I courts, but there is absolutely no principled basis for carving those very important institutions out of their rule.
Well, you're right that the Solicitor General was pressed quite legitimately about things like the tax court and the claims court, et cetera, et cetera. But I don't know that you can make the argument that the logic of his argument is going to cause these allegedly revolutionary results without being prepared to explain more concretely than you have the limits of your own argument. I mean, I could go down the list with you of the cabinet officers and ask you whether you think they could be headed by a multi-member commission whose members are not subject to at-will removal by the president. Shall we do that? How about Veterans Affairs? How about Interior?
Oh man, he's locked in.
Commerce, education. What am I missing?
Agriculture.
Agriculture.
Mr. Agrawal, are you prepared?
Well, there was a question there.
Yes, so I don't want to pretend to greater certainty than I have about the full gamut of statutory authorities vested in all those other departments. I will say that based on a very quick preliminary analysis, it appeared to us that the vast majority of executive departments wield at least some of the conclusive and preclusive authorities that this court has.
Which you can't define.
Including criminal, investigative, and prosecutorial authorities, and also authorities implicating national security and foreign relations. Now, that is not to say, Justice Alito, I think you're absolutely right to say for a lot of those, you could probably take those out, and at that point, there's going to be a fair question about whether Congress and the president acting together could determine at some point that there is a need for a multi-member body of experts to preside over certain government functions. And what I would say is, I don't think that you should categorically rule out.
We're not a
as matter of
technocracy.
Constitutional law, and I don't.
Yes,
I
you
can't
can.
sit here today and tell you that there's a distinction of constitutional proportions, for example, between the Department of Labor and the National Labor Relations.
Well, how about the post office at the time of Myers? How does your exclusive and preclusive theory account for Myers? How can it be that the postmaster at that time exercised exclusive Article II power, but a Federal Trade Commissioner does not?
So I would say three things about that. First, the conclusive and preclusive standard does not have to be the sole and exclusive limiting factor. Second, there is a provision that Justice Barrett referred to in the colloquy with opposing counsel about the take care clause, and it is conceivable that at least in some circumstances, the take care clause might itself, not always, but sometimes, impose a conclusive and preclusive standard, for example, with respect to officers like the postmaster and Myers who are deemed to possess purely executive functions, as this court unanimously in Humphrey's Executor and then again in Weiner unanimously characterized the functions of the postmaster and Myers as purely and obviously just executive. So that's a second constraint.
When you answered Justice Alito about the agencies exercising investigative power, and thus there would be a question whether they could be made independent multi-member commissions, don't a lot of the now independent agencies also exercise that kind of investigative power? At least from my experience, it's very hard to get into the weeds of this particular powers exercised by the FTC and distinguish it from some of the powers exercised by some of the other cabinet agencies that we traditionally think of as executive, or the FCC or the SEC. All of those seem to the FERC, NLRB, when you get into them all. So what's your answer to that?
So my answer is the criminal investigative authority is different, and certainly a lot of these agencies have civil investigative authority, including the FTC. As we understand this court's precedent just from last term in Trump v. United States, criminal investigations and prosecutions are in a different category, at least as a general matter. And if the logical import of that analysis is that is that there are certain functions that cannot be wielded even by traditional independent agencies, then so be it. That's the law of the land.
That's right. I'm sorry.
Go ahead.
Go ahead, please, go ahead.
Go ahead.
All right. I understand conclusive and preclusive entirely as we used it. When you're speaking about executive power, can the president control what's done in his departments? I get that. And a criminal prosecution is a good example. I do not understand it as you use it. Why isn't it just as conclusive and preclusive to decide whether to bring charges under the FTCA Act
Civil
against
charges.
somebody? Civil versus criminal. It's a conclusive and preclusive decision about enforcement decision of the power of the federal government against individuals across the country.
So there's a legal answer and there's an historical answer, and they might blend, Justice Gorsuch. And the legal answer is that we don't have any controlling authority that has ever held that civil enforcement as a categorical matter is the kind of thing that can never be vested in a multi-member agency that enjoys a modicum of insulation from political pressure. And we know that, for example, from this court's unanimous decision in Humphrey's Executor, where you had that kind of civil enforcement taking place, and a unanimous court, including all 4 justices from Myers, said that's okay. And the kind of civil enforcement that was going on there, you had complaints being issued, you had cease and desist orders.
Cease and desist orders, but not lawsuits in court. They had to go to court. And I'm just curious, though. Fine, I accept your point. It's a good point about Humphreys. But why isn't that conclusive and preclusive decision whether to use the federal government's full power in a prosecution where you can seek fines and incur all of the penalties that are associated with violating the FTC Act?
So I think part of the answer is historical and part of the answer is functional. And on the historical part, we have had all kinds of civil enforcement of federal statutes taking place, including just private statutes that authorize private attorney generals, as this court has recognized in many, many cases. So you have a long, long history and tradition of private actors wielding kind of enforcing civilly federal statutes. Now, I take the point that civil enforcement on behalf of the government of the United States.
That's not the executive power, but criminal actions is the executive power.
I would not say that.
That's what you're asking us to.
No, I would not put it that way. I would not say it's not executive. And in fact, in SEALA law.
So it is executive?
In SEALA law, this court said it's not only executive, it's quintessentially executive. And that's okay, because agencies like the FTC also engage in adjudicative activities, and that would be deemed quintessentially judicial, and nevertheless, they're not subject to plenary removal on the part of the judiciary. They engage in rulemaking that could be considered quintessentially legislative, and nevertheless, they're not subject to plenary control on the part of the legislature. The issue is not whether it's executive in some sense. The issue is whether it's constitutionally committed to the president's sole and exclusive discretion, and as a matter of history and precedent, we haven't gotten there yet.
So even some quintessentially executive functions, in your view, are not vested in the President of the United States?
Yeah, I would not say that. I would not say that they're. Yes. I would
Oh,
say
my God.
they're
You
not-
have to say yes to that, based on what you've just.
Right.
They're not
Got 'em.
constitutionally committed to the person of the president and to his sole and exclusive discretion.
Didn't we
Yes.
suggest as much in Humphreys? I mean, didn't we have some lines in Humphreys that say, to the extent that it exercises any executive function as distinguished from executive power in the constitutional sense.
Jackson.
It does so to discharge.
She's going to get Humphreys overturned.
It does so in the discharge and effectuation of its quasi-legislative or quasi-judicial powers. So I thought that in Humphreys.
FTC was deemed not executive.
That you could have an agency that's exercising
In Humphreys.
legislative or judicial powers still engaging in some executive function, and that doesn't make it an executive agency.
That is exactly right. And on top of that, we have a lot of agencies over a long period of time engaging in all manner of civil enforcement of federal statutes. And yet we do not have a single example of any case from this court in more than 2 centuries that has ever held that a single layer of for-cause removal protection cannot apply to a principal officer of an agency wielding that kind of civil enforcement function.
So I think that's like your real point. In other words, you're not asking for some sort of conclusive or preclusive rule. That's not your burden in this situation. You are just saying that the way the law has been interpreted by the court here, the existence of Humphreys and Congress's reliance on these kinds of multi-member agencies for something like 90 years plus, that's the background rule. And so now it's up to the government and the Solicitor General to come in to suggest that there's a constitutional problem with that.
That is absolutely right. We have a 111-year-old statute that was enacted by the people's elected representatives. It was signed into law by a president of the United States. It was unanimously affirmed by this court, and it's been followed by every single president since 1935 until the present. We don't need an abstract theory to tell us that the FTC Act is okay. It's the other side that needs to give you a really compelling theory to explain why, in our view, 200 plus years of precedent and history need to be abandoned. But in any event, even according to by their own acknowledgement, we're talking about the modern era of traditional independent agencies, which spans more than half the life of the Republic.